to Ms. Coates, and you'll give me an opening statement, Ms. Coates, and see where that lands us.
Yes, Your Honor. Mr. Purser is asking for a reset, Your Honor. He is okay with November 7th at 8:30 being the date. Mr. Purser actually has a meeting at 11:15 with his employers. And so I don't know how long that's going to take, but he's asking for a reset. And right now, this is a confirmation of arrears and modification, Your Honor. The issue is that Mr. Purser is going to be asking Your Honor for about $57,305 in direct pay credit. That's at issue. Miss Yana Honovitska is not in agreement to that, and so that's what the main issue at this time is. She's not she's not in agreement to a reset. Again, I'm not sure how long his meeting will take, but that's he's asking for a continuance, Your Honor.
Courtroom falls silent as Miss Coates steps forward to explain the confusion surrounding 6 years of child support payments. She requests a reset, explaining the father, Mr. Purser, has an urgent work meeting. The judge listens carefully, recognizing the issue direct payment credits totaling nearly $57,000. Ms. Tanovitskaya disagrees entirely, sparking immediate tension. As Ms. Coates reveals hundreds of pages of bank records, the judge prepares for a complex financial tug-of-war that will expose years of private transactions and bitter distrust.
Let me see. When were they served, Ms. Coates? Is this their first time here? Not really.
I believe this is our second setting, Your Honor.
Okay.
And he was served or appeared April 25th, and she was served July 11th of this year.
Okay, and the form of the direct pay credits that will be attempted to be proven up, is it in writing? Is it something that needs to be screen shared? Is it all testimony? What are we doing?
It is screen sharing, Your Honor. I believe it's bank statements.
Bank statements?
The first one is about 19 pages. And
it's over a period of time, obviously.
Yes, this goes all the way back. Well, he should have been making payments in 2019, Your Honor, but instead he was making them directly to her. So then the second document is 58 pages.
Ms. Coates details the evident 77 pages of statements, 6 years of payments to banks and Zelle transfers. The judge, realizing the mountain of financial proof, asks how it will be presented. Screen sharing begins, but one problem emerges. Ms. Tanovitskaya can only join by phone. The judge must describe every page aloud to ensure fairness. It's a procedural nightmare. Yet, amid all the technical issues, a deeper issue forms: who really paid what, and why is trust so broken between them?
So that is compiled to like what? All the bank statements over a period of 6 years or something like that?
Correct, Your Honor. So from 2019 until now, so there's, I guess, 2 banks and then a Zelle transactions.
Okay, and thank you. And the other complication is Ms. Tanovitskaya will not be able to see any of the screen share, so I'm gonna have to talk and identify each one, and we have to make sure she knows what we're seeing and discussing, since she's on the phone.
Yes.
That's a rhetorical question, but
I'm not entirely sure why I'm not entirely sure why she doesn't want to give credit, but that's the issue, the credit.
Okay, we're not talking about any of that, the substance yet, Ms. Tanovitskaya, and you'll get your turn in just a minute. I'm just finding out from the state what's at issue. Okay, anything else in the way of an opening statement, Ms. Coates?
No, Your Honor.
Then the state's going to call you as witnesses one at a time, and she gets to decide who goes first. The person who's not testifying, please remain quiet unless you have a valid legal objection. You're going to get your full turn to talk when it's your turn to testify. So just hang in there with me, and I'll hear from both of you one at a time.
The judge regains order, instructing both parties to remain silent until called. She warns this case will proceed without interruptions. The formality sets the tone: calm precision versus raw emotion. Ms. Coates calls the first witness Mr. Purser. The judge confirms his name and intent. He explains the work meeting but insists he's ready to proceed, eager to prove he's been paying. What begins as a scheduling conflict soon unfolds into a father's fight to show years of unrecognized payments.
Without interruptions, Ms. Coates.
Yes. All right. Mr. Purser, can you hear me? I'm sorry if I'm not pronouncing your last name
No,
correct.
you're good. That's correct, man.
You are asking for a continuance because you have a work meeting that starts at 11:15. Is that correct?
Yes, ma'am. If you think we could move quickly, I'm not opposed to moving through this. I was just a little bit surprised how long it took. I think her main objection is she doesn't want to give me credit for it because I didn't pay it to you. So this may go on a while because there's a lot of documentation.
Are you at the office where you have to have the meeting, or do you need to leave?
I'd have to leave here, but I'd like to proceed.
But I'm hearing there's 77 pages, Mr. Purser, of stuff we have to look at, or I have to.
I had 1,100 pages, and I pulled it down to just the transactions. How this basically started is we divorced during COVID. So the banks, you guys were closed to direct the payments. And so we would go to the bank initially, and I would take out $1,250 on the third and just hand it to her. Over a period of time, when Zelle became a possibility, I started using Zelle. So what I did is I worked in reverse from today back towards that time because the Zelle transactions were the most documentable.
Mr. Purser begins explaining his side. Since 2019, he says, he made all payments directly, first in cash, later through Zelle. When COVID hit, banks closed, forcing him to adapt. He meticulously tracked everything, totaling over $68,000, exceeding his obligation. The judge listens, intrigued but cautious. As he talks, Ms. Tanovitskaya silently fumes. His calm tone hides frustration, a man desperate to prove his integrity while facing a system that demands digital proof for every dollar.
So when I got to like 68,000 in Zelle transactions, that was exceeding my obligation. I just stopped there.
Okay, I'm not even sure this thing should be on Zoom, especially if Ms. Tanovitskaya is on the phone today. I don't see getting through a hearing with 77 pages of documentation anytime quick.
And ma'am, I'm completely willing to just, even though I've overpaid, I'm good with just, let's call it even and move forward. I have no doubt she needs the money. And a modification is a certainty. I mean, the two that I had with me are now over 18, and she's got the only one. It's a given there's going to be a modification. I think the hang up is she doesn't want to acknowledge she's been paid more than.
I'm going to stop you there. I don't know what she's going to say or not say on the substance. I'm just trying to figure out if I want to go forward, or if I should make y'all go forward today or not. And, how long is your meeting lasting for?
About 2 hours.
Yeah. We have not a huge docket today, but I don't really want to be around for just your case at 3 o'clock in the afternoon or whatever, maybe 2 o'clock maybe.
Hearing about 77 pages of documents. The judge questions if this complex dispute can even continue on Zoom. She notes the volume, the missing visuals, and the time. Mr. Purser insists he's ready but mentions he's overpaid and only wants closure. He offers peace, let's just call it even. The judge, impressed yet cautious, questions his sincerity. She recognizes a genuine willingness to move forward but also senses the bitterness of years spent defending himself in silence.
Okay, I get it. So, Ms. Coates, any more questions for Mr. Purser?
No.
Then if you want to call Ms. Tanovitskaya.
Ms. Tanovitskaya, can you hear me?
Yes, ma'am, I do.
Okay. I understand you don't want to reset this. Is that correct?
Yes, ma'am. May I explain, please? May I explain?
Explain why you don't want to reset this?
Yes.
Yes.
Yes. Can I speak?
Yes. Why do you think we should not reset this?
Because Buford Purser had 2.5 months since July 11.
He's had too many.
The judge turns to Ms. Tanovitskaya, who immediately pushes back. Her voice shakes with frustration. She argues that Mr. Purser had months to send receipts and failed to do so. She accuses him of ignoring court orders, changing jobs and addresses without notice. Her complaint reveals more than logistics, it's emotional exhaustion. For 2 years, she says, she's waited for justice while raising their child alone. To her, these missing receipts aren't paperwork. They represent broken promises.
Provide me
He's
a
had
bill for this person. He had 2.5 months since July 11 to provide me those receipts. He didn't provide me the receipts. He didn't provide court the receipts. I know he changed his residency, the address. He changed his employment. He didn't notify me as court order about his new address or his new employment. He didn't notify, I wonder, did he notify court with his new address and new employment? Did he? Because this court order. He doesn't like to follow the divorce decree, the order.
So so the issue is not that we don't have the documents today. We have it today. It's just that he's not available because he has a meeting that's going to start soon and will take 2 hours. Is it coming back in November an issue?
Oh, he knew about today. He should have made arrangement already with the work and with everything. He knew how important it is. Because from July 11th...
Ms. Tanovitskaya continues passionately. She explains that since July, she's waited months for the documents. He never sent them. Her anger rises as she recounts unpaid months and vanished support. She accuses him of hiding behind excuses while she struggles financially. Her tone trembles between anger and heartbreak. The judge listens but reminds her the day's issue is past credit, not current delinquency. Still, the emotion lingers. This is no longer about numbers. It's about betrayal and time lost.
It's 2.5 months. He had plenty of time to prepare. He doesn't want it. I requested child support in February 2024, almost 2 years it will be. So one year and 8 months I've been patiently waiting. He stopped making any current child support payments since August 25th. So 33 days he is behind on his child support. Did he notify the court? Why did he stop making child support payment? Why?
Is there a court order for child support, Ms. Coates? I assume there is.
Yes.
There's direct pay credits, right?
Yes, Your Honor. That's the issue.
The issue is not that what he's not doing now, it's what he might be entitled to credit for in the past. So that's not the hearing you want to have, ma'am, why he's not paying now, even if I went forward today. This is about what is it? How many years since 2019?
Yeah.
6 years of payments that I'm going to have to look at 77 pages and you can't see it. Is there some reason you can't log on into the Zoom app and so we can have you present and being able to view documents? Is there some reason you're not on Zoom?
No, I can't. My phone is very old and...
The judge realizes the limitations. One party can't view the evidence, and both are self-represented. She asks why Tanovitskaya isn't on Zoom. The mother admits her phone is too old, it keeps disconnecting. The judge sighs. In the digital age, even technology seems to work against her. Still, Tanovitskaya clings to her divorce decree, claiming it already proves his obligations. The judge cuts her off, saying the focus today is logistics, not proving guilt, yet the tension only deepens.
It's maxed up all the members, it kicks me off. I can't use it. But I have divorce decree which he signed up and he agreed to. And on the page 25 of divorce decree, it says...
we're not talking about that right now, Ms. Tanovitskaya. I know you want to prove your case, but I'm just trying to do the logistics on whether it's feasible to do a hearing today right now under these circumstances or not. So that's what I need to address. Do you live in Comal County?
Yes, ma'am. I'm in Comal County.
Mr. Purser, are you in Comal County?
Yes, ma'am.
Because, not everything is meant for the computer. And today on the phone, especially Ms. Tanovitskaya, I'm going to have to do a lot more work to make sure you know what's being shared on the screen that you cannot see. So I have to talk about everything on it and what it says and what it is, and you can't see it for yourself. Now, has Ms. Tanovitskaya been given copies yet of any of the documentation, Mr. Purser, or just the state?
Just the state,
Oh.
ma'am.
Frustration builds as the judge realizes 77 pages cannot be reviewed online. She proposes moving the case to an in-person courtroom. Both sides agree. It's the first moment of unity since the hearing began. The judge explains that this case demands fairness, real evidence, real copies, and real presence. After years of confusion and remote hearings, both sides will finally face each other in court. Justice, it seems, will require eye contact, not just internet connections.